Please be seated. Good afternoon. We call now the case of Medellín versus State of Texas, and we'll hear first from the petitioner.
Mr. Chief Justice, and may it please the Court, my name is Enrique Schaerer, and along with my co-counsel, Michael Krouse, I represent the petitioner, Jose Ernesto Medellín. I will address the first question, whether the President has the authority to execute the ICJ's Avena judgment in state courts, and my co-counsel will address the second question, whether U.S. treaty law requires states to comply with Avena. With the Court's permission, I would like to reserve 3 minutes of my time for rebuttal.
Yes, you may.
Your Honors, in foreign affairs, we are but one people, one nation, one power, and this power is vested in the President as the sole organ of international diplomacy. In this case, the President seeks to execute Avena in state courts as a matter of foreign policy, and that action should be upheld and given preemptive effect by this Court by virtue of federal supremacy.
And as I understand your brief, you're saying that that authority exists independent of the treaties. I mean, you're saying that the treaties support it, but that the President has this authority even without the treaties. Is that correct?
Your Honor, that's correct. We believe that he has the independent constitutional authority to take this action by virtue of Article 2 of the Constitution.
So he can put any matter that involves a foreign national or foreign issue into or out of a state court as he thinks is in the best national interest?
No, Your Honor, not necessarily. That is why we situate the President's action in this case within a context of shared institutional powers, best articulated by Justice Jackson in his Youngstown concurrence. Because the President has explicit or implicit congressional authorization in this case, then his hand is strengthened. He acts with his maximum authority, and that's the reason why we believe the President wins today. Now, if the President were to act—
That does depend on the treaties, then, on Congress's having approved these treaties, correct?
Your Honor, to answer your question, no. The President could still act with his independent constitutional authority. Now, if he were to act with that independent constitutional authority in contravention of a constitutional principle or independent provision, then he would not be able to act. But in this case—
But are you saying that he has either explicit or implicit authority from Congress to act in this area where he's not plausibly enforcing a treaty?
Your Honor, it would have to implicate foreign relations.
So let's just imagine that Mexico is upset because so many of its nationals are being held in the United States and that there's no treaty involved. Could the President do the same thing in order to resolve this foreign policy conflict with a friendly nation?
Your Honor, we believe that the President could in that case.
What would be the explicit or implicit congressional authority for doing that?
Your Honor, the authority would derive from Article 2 of the Constitution.
We were talking about congressional. You were talking about this being in the #1 category in Youngstown,
correct,
which requires congressional authorization. What would it be?
Your Honor, in this case, we would be in Youngstown 2, if that were the case. And if there were no congressional authorization, the President would have to rely—
Congressional silence. Right?
Yes, Your Honor. And as Youngstown—
So in order to get into Youngstown Category 1, then you have to be arguing that Congress has authorized this, and that depends upon it being an enforcement of the treaty.
Correct, Your Honor. And
so
that
if
is—
we conclude in the second part of this our argument that the treaty does not require enforcement, then we are no longer in the first category of Youngstown.
Not necessarily, Your Honor. In this case, we argue that the UN Charter, which is U.S. treaty law, and the UN Participation Act, which is a federal statutory law, together put the President in charge of foreign relations with the United Nations. So he's entrusted with making UN-related foreign policy decisions. And remember, the ICJ is the judicial organ of the United Nations.
Everything regarding the United Nations?
No, Your Honor, because the President would still be limited in his actions by the Constitution, independent provisions and principles. So he cannot just act—
But in terms of the separation of powers issue, anything regarding the United Nations?
Not if Congress has spoken, Your Honor.
So if the General Assembly passes some resolution on environmental law or whatever, the President then has the authority to preempt state law?
No, Your Honor, and that's why we situate his power within Youngstown framework. If he were acting in the face of congressional disapproval, the Congress, his power would be at its lowest ebb, and
You
this
just
court...
told us that everything having to do with the United Nations, Congress has authorized him to act.
No, Your Honor.
What are the limits to your position?
The limit, Your Honor, the limits are congressional disapproval expressed in other statutes, none of which respondent is able to cite to, and also independent constitutional provisions and principles.
Like what? Give me a constitutional principle that you think limits the ability of a president to put a case in or out of a state court if it involves a foreign national and a foreign policy concern. What provisions of the Constitution?
Your Honor, I will give you a principle, the principle of anti-commandeering expressed in Prince. If the President were to say, I want the state executives to grant clemency, that would be acting in contravention to the authority he received from Congress.
In your papers, you said that there's no problem of commandeering because, after all, it's only the judiciary. Is that right?
That's correct, Your Honor.
You don't think the judicial branch of a state government is a part of that state government and that you're commandeering it?
No, Your Honor, I'm using the court's own language. This court held in Prince that courts should be treated distinctively in this regard because, unlike legislatures and executive, courts apply the law of other sovereigns all the time. So this is a very narrowly crafted directive, Your Honor.
Has it occurred to you at all that this really sounds sort of like a bill of attainder? That is to say, it's a demand on a particular court to take a particular action in a given case?
No, Your Honor, we don't believe that is the case. In fact, this court has upheld similar representations of foreign policy from the executive in other cases. In Ex parte Republic of Peru, this court enforced the State Department's request to grant immunity to a Peruvian vessel, and it was the State Department that had requested it, and because the State Department requested it, this court said that it was bound by that decision. It actually said that courts are required to accept and follow the executive determination that the vessel is immune. Because
but in this case, we're talking about reopening a final judgment, and just as the anti-commandeering principle of Prince, you say, limits the president. Well, what about the principle of Plout versus Spendthrift Farms that the political branches cannot reopen a final judicial judgment?
Your Honor, we don't believe that implicates it here because this has not been final in the eyes of the International Court. That there's still an open question of whether there was a Vienna Convention violation, Your Honor.
It's final in terms of United States law.
Your Honor, it's still a question even within the United States because this court has to rule on this issue. And we believe that if you were to look at comparable principles like the Younger abstention doctrine, that's not implicated here either, Your Honor.
In that case, Plout means nothing because whenever the president decides to reopen a settled judicial matter and it goes to the Supreme Court, you can always say, well, it's not final yet because we haven't decided yet whether the president can reopen it.
Your Honor, we believe that this is an ongoing litigation that needs to be granted respect.
But it's not ongoing. It's over. You're asking to reopen.
No, Your Honor. It's over in the eyes of the state of Texas, but that is the problem in this case, Your Honor, that the president needs the authority to be able to say, look, this implicates our foreign policy.
Could he reopen a federal case?
Your Honor, if there was a comparable situation in which...
well, if someone had been prosecuted federally and had not gotten their consular rights, are you saying that the president has the power to tell the judicial branch of the federal government that it has to reopen a case, even in light of Supreme Court decisions like Breard and
No, Your Honor.
So
in that case, no.
He couldn't do it to the federal to a federal court?
No, the reason, Your Honor, he couldn't do it in that case is because he would be asking a federal court to review a successive habeas petition involving a claim that was not originally raised at state trial, and that would go against the congressional will in the anti-terrorism.
I'm trying to understand the logic of your suggesting to us that the president's power, foreign policy power, is greater with respect to a state judiciary than the federal courts.
Your Honor, the reason is because Congress has spoken on this matter, and I'm taking us back to the Youngstown category. That would place the President's actions in Youngstown 3, because Congress has said in the Anti-Terrorism and Effective Death Penalty Act, federal courts cannot re-entertain these cases. That is why the President's decision in this case is narrowly crafted. He directs his order to comply and discharge of our international duties to state courts.
But one of the overriding principles of the Anti-Terrorism and Effective Death Penalty Act is deference to the actions of state courts, and one of the primary ingredients of that deference is deference to state procedural rules as the state courts have applied them.
Your Honor, that is one way of viewing it, but we believe that with the United Charter Act and also with the UN Participation Act, as well as 22 U.S.C. Section 4802, that empowers the Secretary of State under the auspices of the President to protect foreign nationals in this country, and the Hostage Act, which
empowers... And what did the Secretary of State do in this case? The President's memorandum was addressed to the Attorney General.
Correct, Your Honor, but this
so
power...
how could you possibly be invoking the authority of the Secretary of State?
Your Honor, what we're saying is we're taking this court back to its holding in Dames and Moore, where this court held that it was the general tenor of congressional legislation that gives implicit congressional authorization.
Tell us again, where is the congressional authorization?
Your Honor, we argue that there's implicit authorization in the UN Charter. We argue...
What are the words of the statute you're invoking?
Your Honor, the UN Charter specifies that if we do not comply with the decisions of the ICJ, then the United States will be confronted in the Security Council. The President has a vested interest.
So your argument is that even now that we have withdrawn from the optional protocol and no longer recognize the ICJ, if the next case will come out exactly the same way? Because it isn't pursuant to that, it's pursuant to something else.
No, Your Honor. I'm arguing that because of the UN treaty law that we have...
But that applies even if we withdraw from the optional protocol, as we have.
And correct, Your Honor, that was a presidential decision to withdraw.
That's the President's authority. What you're saying is that he will be able to do this even for future cases.
No, Your Honor. What I'm arguing is that the ultimate check ultimately resides with Congress, as this court held in Whitney versus Robertson.
But only if Congress enacts legislation to stop him.
Under this court's analysis in Dames and Moore, that would be one interpretation, Your Honor.
Well, we have never confronted a situation where the executive has tried to dictate to a state how to proceed in a criminal matter, right?
Correct, Your Honor.
Right. So, you know, it's difficult to tell us that this is controlled by our precedent. You're saying that unless Congress passes legislation that stops him, the President of the United States can go into any state proceeding involving a foreign national, and if he deems it in the interests of our foreign policy, tell the state whether to abandon statutes of limitations, reduce sentences, take a new look despite procedural defaults. He has that broad a power. Is that right?
Your Honor, see, my time has expired. May I answer your question fully?
I think that one.
Your Honor, Your Honor, no, that is not what we're saying, and I'm glad that you raised that question. We are arguing that the President, when he acts legitimately and does not act in contravention of another constitutional provision or principle, and he has some sort of implicit congressional